Well, hello everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. I'm your host, Uncivil Law, a licensed attorney in both Texas and Virginia. We are here with a recent Supreme Court decision that people have asked me for a deeper dive into, and today I thought we'd do exactly that. This is the case of Alabama versus Milligan. This is a redistricting case. It deals with where lines are drawn on the map for congressional districts. It was decided, at least in part, under the Voting Rights Act. This is a case that deals with this issue that by law starts in a three-judge trial court. So, of course, most of the time when you have trial courts, it's a single judge. Redistricting cases are one of the exceptions to the rule. In those kinds of cases, it's a three-judge district court. And then it is a right of appeal, not writ of certiorari, to the U.S. Supreme Court. So the U.S. Supreme Court doesn't get the choice as to whether or not to hear this kind of case because they are the courts of appeal. That's how that's set up by Congress. These used to be a little bit more common with the three-judge district court thing. In the late 80s, there was a Reform Act that took a lot of that away because the Supreme Court was hearing so many cases by mandatory review that was a little bit burdensome. And so they kind of undid that, but this is one of those holdovers. Anyways, that's on the technical grounds. We're going to read this, try to understand it, and see what broad principles it has, or see if it's more just a fact-specific case that doesn't really speak to any broader issue. So is this just facts applied to law? Are we creating new law? Refining law? How are we dealing with this in this sort of universe? This is a 5-4 decision. So we're going to read this and try to understand it and see what's going on. Alabama versus Milligan. Okay, let's see what we got. Chief Justice delivers the opinion of the court, and we will skip the syllabus and just read the opinion of the court because we're doing a deep dive today. In January 2022, a three-judge district court sitting in Alabama preliminarily enjoined the state from using a districting plan it had adopted for the 2022 congressional elections, finding the plan likely violated Section 2 of the Voting Rights Act. This court stayed, that is, enjoined the order, pending further review, but now affirms. So the district court said you can't use the map, and now the Supreme Court on appeal, not writ of certiorari, on appeal, says we're going to review this. All right, so yeah, you can see that right up in the title here, on appeal from the United States District Court. It's right in the title. So, and there was also some sort of related case that was also by certiorari, and this is also before judgment to the Court of Appeals. So there had been a trial court decision, but no decision by the Court of Appeals. So they're like, yoink, ours. So we will take it out of order and deal with it ourselves. Great, fine. So we consolidate those two cases, and now we're dealing with it. Shortly after the Civil War, Congress passed and the states ratified the 15th Amendment, providing that the rights of citizens of the United States to vote shall not be denied or abridged on account of race, color, or previous condition of servitude. In the century that followed, however, the amendment proved little more than parchment promise. Jim Crow laws like literacy tests, poll tax, and Gord moral requirements abundant, rendering the right to vote illusory for blacks. Congress stood little of it. The first century of congressional enforcement of the 15th Amendment can only be regarded as a failure. That changed in 1965. Spurred by the Civil Rights Movement, Congress and President Johnson signed into law the Voting Rights Act. The act created stringent new remedies for voting discrimination, attempting to forever banish the blight of racial discrimination in voting. By 1981, in only 16 years' time, many considered the Voting Rights Act the most successful civil rights statute in the history of the nation. Fair enough. These cases closely concern Section 2 of the Act. In its original form, Section 2 tracked the language of the 15th Amendment, and as a result had little independent force. Yeah, if they're just going to repeat the language of the Constitution and statute, then what's kind of the point? Our leading case on Section 2 at the time was City of Mobile versus Bolden, which involved a claim by black voters that the city's at-large election system effectively excluded them from participation in election of city commissioners. The commission had 3 seats. Black voters comprised a third of them, but no black candidate had ever won the election. So an at-large system just basically means that everyone represents everyone, right? Rather than breaking them up into individual districts where there's one representative per district, we're going to have a system where there are X number of people who are on the city council, but they represent the entire city. All of them represent the entire city. So that's at large, right? We're going like 5 people or 10 people or 15 people or whatever the number is, but they don't represent individual wards or individual segments of the city. They represent the entire city. And so even though the blacks comprise a third of the city, they didn't get any of the candidates because it's at large. So they weren't able to muster enough votes to win any candidates, no matter how many seats there were. All right. The courts ruled against the plan. The 15th Amendment and thus Section 2 prohibits states from acting with racial discriminatory motivation or invidious purpose to discriminate, but it does not prohibit laws that are discriminatory only in fact. This is generally true when we talk about discrimination, right? It's illegal to discriminate depending on exactly what statute we're talking about, but it's illegal to discriminate on the basis of sex, basis of race, basis of disability, basis of whatever. But you have to be discriminating for that reason. All right. You can look to impact as a way of teasing out whether or not that was someone's motivation. But impact alone doesn't create discrimination, right? So no matter how much impact there is, right? If the impact is just a natural consequence of a truly neutral policy, which maybe it's not truly neutral, maybe it was adopted for that reason, but if it is truly neutral, all the impact in the world won't get you past there. You have to be discriminating because of that reason. That's typically true. The plaintiffs could register and vote without hindrance. Their freedom to vote had not been denied or abridged by anyone. The fact that they happen to lose frequently was beside the point. Nothing the city done to purposely exclude them from participating. Okay, fair. That's what the court said. Almost immediately after it was decided, Mobile produced an avalanche of criticism, both in the media and within the civil rights community. The 1982 amendments to the Voting Rights Act in the history. The New York Times wrote the decision represented the biggest step backwards in civil rights to come from the Nixon court. And the Washington Post described Mobile as a major defeat for blacks and other minorities fighting electoral schemes that exclude them from office. By focusing on discriminatory intent and ignoring disparate impacts, critics ignored, the court had abrogated the standard used by the courts to determine whether racial discrimination exists. Well, I don't think that's quite correct. I don't believe that it's impact qua impact. It is impact in so much as it highlights or reveals discriminatory purpose. So I think the critics might be misunderstanding the law. But what else is new? But Mobile had its defenders too. In their view, abandoning the intent test in favor of an effects test would inevitably require a focus on proportionality. Whenever a minority group won fewer seats in the legislature than its share, the charge could be made that state law had discriminatory effect. That, after all, was the type of claim brought in Mobile, but mandating racial proportionality election was regarded as many as intolerable. Yeah, that doesn't seem like that's the right answer. It doesn't quite seem correct that just because half the population is X, therefore half the legislatures should also be X. Maybe that's not what the people want. And the people are entitled to their choices for better or worse. So just because it's not proportional doesn't necessarily mean it's not good. Doing so, wrote Orrin Hatch in the Washington Star, would be strongly resented by the American public. The Wall Street Journal offered a similar criticism. An effects test would generate more, not less, racial and ethnic polarization. That debate arrived at Congress's doorstep in 1981. The question of whether to keep Section 2 as is or not involved one of the most substantial constitutional levers to come before the court. Now, on just purely like a philosophical level, I don't know whether or not the Supreme Court was right in its decision on Mobile, because I don't remember if I've ever read that decision. But if it was right, then this is the way it should be, right? The court is supposed to give effect to the law as it exists, not the way they want to be. There's a difference between is and ought, right? The courts do is. Congress does ought. If you want the short definition, courts do is, Congress do ought. Congress does what should be. Courts do what is. Great. So if what is not the way it's supposed to be, then great. Go to Congress. That's what they're for. And sometimes I feel that when the judicial branch steps in, when it's not supposed to, it somewhat undermines the political pressure. Because, well, let's just tell you what reality is. And if you want to go change it, change it. Don't talk to us about it. Why do you want us to fix your problem, Go to talk to someone else about it. That's right. I like that very much, philosophically. Proceedings in Congress mirrored the disagreement that had developed. In 1981, congressional chairman introduced a bill to amend the Voting Rights Act, proposing the words deny or abridge be replaced with the phrase in a manner which results in denying or abridging. Okay, great. Congress is now having the exact same debate that they were having in the whole thing. Great. Go figure out which one you want and then tell me about it, and I'll be happy to do that. That'll be fine. Great. But those worry the proposition proportionality were not far behind. Senator Hatch argued the effects test was intelligible only to the extent it approximated a standard of proportional representation by race. The Attorney General had the same concern. The effects test would be triggered whenever election results did not mirror the population, he wrote, essentially a quota system. The impasse was not resolved until late 82, which is pretty fast for Congress, to be quite honest, but okay. Senator Dole proposed a compromise. Section 2 would include the effects test that May desired, but also a robust disclaimer against proportionality. Seeking to navigate tension between the two, the Dole Amendment borrowed language from the 14th Amendment case of the Supreme Court, which many in Congress believed would allow courts to consider the effects but avoid proportionality. The standard for liability in voting cases was whether the political process leading to nomination election was not equally open to participation by the group in question, in that its members had less opportunity than did other residents in the districts to participate in political process and elect legislatures of their choice. The Dole Amendment won bipartisan support, and the Senate passed it. 11 days later, the president signed it. Hooray! Congress has done a thing. Let us learn what Congress has done. The amended language reads as follows. No vetting qualification or prerequisite to voting or standard, practice, or procedure shall be imposed or applied by any state or political division in a manner which results in a denial or abridgment of the right of any citizen of the United States to vote on account of race or color and other language, as provided for in subsection B. A violation of subsection A is established if, based on totality of the circumstances, it's shown that the political processes leading to nomination or election in a state or political subdivision are not equally open to participation by members of a class of citizens, in that its members have less opportunity than other members of the electorate to participate in the political process and elect representatives of their choice. The extent to which members of a protected class have been elected to office in a state or political subdivision is one circumstance which may be considered, provided that nothing in this subsection establishes a right to have members of the protected class elected in numbers equal to the proportion of population. Okay, fine. So so the Supreme Court interpreted the law. People didn't like the law. They went to Congress. Congress, looking for a solution to the problem, found some language in a 14th Amendment case that they thought might be helpful. So they're like, okay, this 14th Amendment language from the Supreme Court in this 14th Amendment case kind of looks interesting. Let's borrow it. Let's borrow the language and put it into statute form in the Voting Rights Act, but with this additional qualifier. Great. All right, Congress has done a thing. Fantastic. Let's go do that now. All right. For the 115, thank you for all the raid people very well, by the way. I appreciate all you guys are here in Vice's chat. Just by way of brief backdown to re-edify the people who are joining us, we're doing a deep dive today into a recent Supreme Court decision. We're doing the case of Alabama versus Milligan. This is a case dealing with redistricting in the United States on racial lines, decided at least in part under the Voting Rights Act. We are reading the opinion and trying to determine the degree to which it's merely a pure factual, pure facts just applied to the situation on the ground, or whether it's new law. This is a case on appeal to the U.S. Supreme Court rather than a writ of certiorari. This is appeal. So the Supreme Court doesn't get to have the choice. So it is very possible the Supreme Court could just be like, yeah, the district court's fine. We're not going to do anything because, the district court was right. So this could just be pure facts applied to already existing law or a modification of law, and we're trying to determine which one. Thank you for joining me as we try to figure this out. I hope you enjoy this. Also, please reminder just to check your subscribe button and like button while you're here. Great. For the first 115 years following Reconstruction, the state of Alabama elected no Black representative to Congress. In 1992, several plaintiffs sued the state, alleging it had been impermissibly diluting the votes of Black Alabamans in violation of Section 2 of the Voting Rights Act. The lawsuit produced a majority district in Alabama for the first time in decades. And that fall, Birmingham lawyer Earl Hillard became the first Black representative from Alabama since 1877. Alabama's congressional map has remained remarkably similar. The map contains 7 districts, each of which with a single representative. And then they go on to specify the geography of the districts in words, but we'll skip that part. In 2020, the decennial census revealed that Alabama's population had grown by 5.1%. A group of plaintiffs led by Alabama legislatures sued the state, arguing the existing map was malapportioned and racially gerrymandered in violation of the Equal Protection Clause. I mean, the population has grown. So, yeah, you probably need to change. And even if the population was literally exactly the same, people probably moved. So, you need to redraw the lines because the districts have to be the same population. So, even if the population was exactly the same from one census to the next, you're probably going to have to move the lines a little bit. Probably everyone isn't exactly where they were the first time around, right? So yeah, you got to move the lines because the people change. While litigation was proceeding, the Alabama legislature on reapportionment began to create a new district and map. Although the prior decade's population did not change the number of seats, the growth had been unevenly distributed. Yeah. I mean, I would think you'd have to do it in any event. Again, even if the population literally was exactly the same, it's probably not true that everyone is exactly where they were 10 years before. So you probably have to redraw the lines in any case, I would imagine. To solve the problem, the state turned to an experienced map maker who had created several maps over the past 30 years. The starting point was the then existing map. Great. Itself a product of a previous map. Okay. They worked to adjust the map in accordance with redistricting guidelines set by the committee. Those guidelines prioritize population equality. That's good because that's constitutionally required. Contiguity, also required. Compactness, also required. And avoiding dilution and minority voting strength. The last part, maybe not so much, but the first 3 definitely required. They also encouraged, as a secondary matter, avoiding incumbent pairings, respecting communities of interest, minimizing numbers of counties in each district, and preserving cores of existing districts. Okay. So, yeah, they avoided incumbent pairings. So they made sure that when they redrew the lines, they didn't redraw the lines in such a way that 2 people who held office at the same time were suddenly within the same boundaries. Because that would be bad because only one of them could win, and we want to make sure that they both can win, right? So when we're redrawing the lines, we take note of the homes of the currently elected legislatures to make sure that we don't put 2 of them in the same district. How thoughtful. The resulting map largely resembled the 2011 map, again producing only 1 district in which the Black voters constitute a majority of the population. The Alabama legislature enacted the map. The governor signed it into law. Fantastic. 3 groups of plaintiffs brought suit seeking to stop the Secretary of State from conducting elections under the map. There was a group of people who sued. Fine. They're suing based on racial gerrymandering. Okay. A 3-judge district court was convened, which is how we do racially gerrymandering cases, or really any line drawing cases on congressional districts. Congressional districts, 3-judge court, 3-judge trial court. An unusual procedure for most cases, very usual for this kind of case. The 3-judge court there was a circuit judge and 2 district judges. Fantastic. The actions were consolidated for the purpose of preliminary injunction, while a different case proceeded before a different judge on a parallel track. A preliminary hearing was conducted. At the time, the 3-judge district court received live testimony from 17 witnesses, reviewed more than 1,000 pages of briefings, 350 exhibits, and considered arguments from 43 different lawyers who appeared in the litigation. Oh, fun. That's going to be a fun hearing. 43 different lawyers to hear from. Wow. Okay. After reviewing an extensive record, the court concluded in an opinion the question about whether or not the law violated the federal law was not a close one. The court thus preliminarily enjoined them from using the map in the forthcoming elections. Okay. Why do the courts consider people based on skin color instead of more logistical aspects? Because the law says they're supposed to. Moving on. 4 days later, on January 28th, Alabama moved in this court for a stay. The court granted a stay and because the Voting Rights Act. 4 days later, Alabama moved in the court for a stay of the district injunction. The court stayed the injunction and scheduled argument while we were trying to figure out what the hell to do. Fine. The district court found there's a problem. We affirm. All right, there's a problem. For the past 40 years, we've evaluated claims under Section 2 using a 3-part framework developed in our decision of Thornburg. Okay. The case concerns a challenge to North Carolina's multi-member districting scheme, more than one member per district, which allegedly diluted the vote of Black citizens. The case presented the first opportunity since 1982 amendments to address how the new Section 2 would begin. Okay. So we've never decided a case under the revised language of Section 2. So let's do that now. The prior case began a description, or apologize, the Thornburg case was the first case to decide. Not the case we're just doing now, I misspoke. The case began by describing what Section 2 guards against. The essence of a Section 2 claim, the court explained, is that a certain electoral law, practice, or structure interacts with societal and historical conditions to cause an inequality in the opportunities enjoyed by Black and white voters. That occurs when an electoral structure operates to minimize or cancel out minority voters' ability to elect their preferred candidates. Such a risk is greatest when minority and majority voters constantly prefer different candidates, and when minority voters are submerged in a majority voting population that regularly defeats their choices. To succeed in proving a violation under the relevant law, plaintiffs must satisfy 3 standards. First, the minority group must be sufficiently large and geographically compact to constitute a majority in a reasonably configured district. So one of the when we're drawing lines on maps, we need to do 3 things. We need to make sure that they're even in population. We need to make sure that they're contiguous. That is that, that all of one district is in its own territory. There's no enclaves and enclaves or anything like that, right? So the boundary lines are like state lines, right? There's no state that exists within part of another state, so they have to be clean in that way. They have to be contiguous and compact, which is where things get sometimes tricky, but they have to be, well, not so sprawling as to be ineffective. So we have to make sure, so if the minority, so to illustrate the point, if you assume that the minority population in the relevant state is evenly spread out throughout the state, then that is obviously not going to allow for a compact district. But if they're all located in one place within the state, then you could theoretically draw lines to include them. All right. A district will be reasonably configured, our cases explain, if it comports with traditional districting criteria, such as being contiguous and reasonably compact. We've spoken about that. All right. Secondly, the minority group must be able to show that it's politically cohesive. And third, the minority must be able to demonstrate that the white majority voter sufficiently as a bloc to enable it to defeat the minority candidate. Finally, a plaintiff who demonstrates these 3 preconditions must also show under a totality of circumstances the political process is not equally open to minority voters. Okay. Each of these preconditions serves a different purpose. The first, focused on geographic compactness and numerosity, is needed to establish the minority has a potential to elect a representative of its own choice in some single member district. So step 1, they need to exist within the state in such a way that it is at least theoretically possible to draw lines to include them, because otherwise this whole discussion is pointless. The second, concerning the political cohesiveness, shows that representatives of its choice would in fact be elected. So if it doesn't matter, then why are we doing it? The third precondition focuses on racially polarized voting, establishes that the challenged district thwarts a distinctive minority vote, at least plausibly on account of race. And finally, totality of circumstances inquiry recognizes the application of the factors is peculiarly dependent on the facts of each case. Before courts can find a violation, they must conduct an intensive local appraisal of the election mechanism at issue, as well as searching practical evaluation of past and present realities. This case has governed our jurisprudence since it was decided 37 years ago. Congress has never disturbed our understanding of it, and we have applied it in one case after another to different kinds of systems and different jurisdictions. So, this is what we've been doing. Congress hasn't changed the law again to say we were wrong, so we're going to keep doing it. Fantastic. As noted, the district court concluded the plaintiff's claim was likely to succeed under the relevant law. Based on a review, we agree. With respect to the first precondition, the district court correctly found that black voters could constitute a majority in a second district that would be reasonably configured. Okay. The plaintiffs adduced 11 illustrative maps, that is, district wing maps that Alabama could enact, each of which contained two majority districts that comported with traditional districting criteria. So, yes, it can be done. Here are 11 examples that prove the point. Fine. With respect to compactness, for example, the district court explained the map submitted by one of the experts performed generally better on average than did the state law. Okay. A map offered by another expert produced district roughly as compact as that as the existing plan, and none of the maps contain any tentacles, appendages, bizarre shapes, or any other irregularities that would make it difficult for them to find to be sufficiently compact. Okay. Plaintiff's maps also satisfy other traditional criteria. They contain equal populations. That's good. We're contiguous. Very good. And respect existing political subdivisions such as counties, cities, and towns. Some people like that kind of thing. So they will tend to try to draw lines to respect other existing political boundaries where possible. So that is something legislatures often do. Indeed, some of the plans proposed maps split the same number of county lines or even fewer county lines than the state map. We agree with the district court, therefore, the map strongly suggests that black voters in Alabama could constitute a second map. Okay, great. We have produced a bunch of alternative maps. These alternative maps show that we could do this, and they satisfy all the traditional criteria that we're also looking for along the way. Great. That's good news. The state nevertheless argues that maps were not reasonably configured because they failed to keep together a traditional community of interest within Alabama. A community of interest, according to Alabama's districting guidelines, is an area with recognized similarities of interest, including but not limited to ethnic, racial, economic, tribal, social, geographic, historical identity. Alabama argues the Gulf Coast region of the southwest of the state is such a community of interest, and they erred by separating into two different districts. That seems kind of nebulous, but okay. We do not find the argument persuasive. Yeah, okay, that seems a bit, yeah. Only two witnesses testified the Gulf Coast was a community of interest. The testimony provided by one of the witnesses was partial, selectively informed, and poorly supported. The other witnesses, meanwhile, justify keeping Gulf Coast together simply to preserve its political advantage. You start splitting the counties, and the county loses its influence. That's why I don't want Mobile County to be split. The district court understandably found this testimony insufficient to sustain Alabama's overdrawn argument there can be no legitimate reason to split the Gulf Coast region. Yeah, that doesn't sound very persuasive to me the way it's being recited. I have to agree. Even if the Gulf Coast did constitute a community of interest, moreover, the district court found that plaintiff's map would still be reasonably configured because they joined together different communities of interest called the Black Belt. Named for its fertile soil, the Black Belt contains a high proportion of black voters who share a rural geography, concentrated poverty, unequal access to government services, lack of adequate health care, and lineal connection to many enslaved people brought there to work in the antebellum period. The district court concluded correctly under our precedent that it did not have to conduct a beauty contest between the maps and the states. There'd be a split community of interest in both. Okay. So, fine. So both maps have the same underlying problem. To the extent that plaintiff's maps have this problem, the state's map also have this problem, just in a different place of the state. Okay. So you can't simultaneously say, essentially, that the Gulf Coast is a special place that can't be split up, and also simultaneously say the Black Belt isn't, basically. It's the same problem. So that undermines the state's argument. Okay, that makes sense. The state also makes related arguments based on core retention, a term that refers to a proportion of districts that remain when a state transitions from one redistricting plan to another. Here, by largely mirroring the 2011 plan, the law performs well on that core retention metric. Plaintiffs' illustrative plans, by contrast, naturally fare worse because they change when district lines were drawn. But this court has never held that a state's adherence to a previously used districting map can defeat a Section 2 claim. So just because you are using a map that is based on the prior map doesn't mean that this is violative. Thank you, Ellen Parker, for the 20 gift memberships as always. That is very, very thoughtful of you. Thank you for your continuing support of the channel. It is extremely appreciated, and we do appreciate everyone who is part of the channel. Yeah. So just because the prior map was legal doesn't mean the new map is. Because again, people move around and demographics change. So you have to look at the new realities on the ground. You can't just say, oh, the old map was legal, therefore the new map is also legal. Oh, our new map is legal because we based it off the old map and you thought that was legal. The facts on the ground have changed. And so you can't just say that one flows from the other. Yeah, that makes sense. Section 2 does not permit a state to provide some voters less opportunity to participate just because it might have done it before. Oh, yeah, also to the extent you were sinning before, you're still sinning. So just because it was approved before, and wasn't successfully challenged doesn't mean it's right either. So, yeah, you might have gone away with it, but yeah, that's not enough. And thank you again for all the people from Vices who are joining this channel, and to the 250 of you who are here for a deep dive on a legal education stream. This is really interesting stuff. Let's see. Why are we not looking at a thing like this with the census and redraft districts? We are. That's exactly what we're doing. I don't understand your question. Let's see, where were we? As the second and third preconditions, the district court determined there was no serious dispute that black voters are politically cohesive, nor they challenged districts' white minority sufficiently as a bloc to usually defeat black voters' preferred candidates. Court noted on average, black voters supported their candidates of choice with 92% of the vote, while white voters supported black candidates 15% of the time. Plaintiff experts described the evidence of racially polarized voting in Alabama as intense, strong, and clear. Even as Alabama's experts concede the candidates preferred by white voters in the areas they look to regularly defeat the candidates preferred by black voters. Okay. Finally, the district court concluded that plaintiffs had carried out their burdens at totally other circumstances stage. The court observed that elections in Alabama were racially polarized. Black Alabamans enjoy virtually zero success in statewide elections. That political campaigns in Alabama have been characterized by overt or subtle racial appeals. And that Alabama's extensive history of repugnant racial and voting discrimination is undeniable and well documented. We see no reason to distort the district court's careful factual findings, which are subject to clear error review as to facts. Yes. And so go unchallenged in Alabama in any event. Nor is there any basis to upset the district court's legal conclusions. The court faithfully applied our law and precedent and correctly determined that it violates the law. Okay. So this doesn't feel like it's setting any new law. This feels like just application of old law to me. It just feels like a fact specific application of currently existing law. So maybe we'll read some of the dissents and see if we can tease out why the dissent seems to think there's a problem. But so far, this seems to make sense. The heart of these cases is not about the law as it exists. It's about Alabama's attempt to remake our jurisprudence. The centerpiece of state's efforts is what it calls the race-neutral benchmark. Theory behind it is this. Using modern computer technology, map makers can now generate millions of possible maps for a state. These maps can be designed to comply with traditional districting criteria, but not to consider race. The map maker can determine how many majority-minority districts exist in each map, and then calculate the median or average number of majority-minority districts in the entire multi-map set. That number is called the race-neutral benchmark. Okay. The state contends that this benchmark should serve as the point of comparison. The benchmark, the state says, was derived from maps that are race blind, maps that cannot have denied or abridged anyone's right to vote on account of race because they never took it into account in the first place. Courts in Section 2 cases should therefore compare the number of majority minority districts in the state's plans to the benchmark. If those numbers are similar, if the state's map resembles the benchmark in this way, then they argue the map can also have denied or abridged anyone's right to vote on account of race. Okay. So we want to use a computer to create millions of different possible maps and then look at basically the average of all the created maps and how many majority minority districts are created by the computer. And whatever that number is the race neutral number. And so if our map that we draw has the same number as the average, then we can't be racist because the computer isn't racist. Hmm. Okay. I'm not sure about that argument. I'm going to let that sit and ponder for a minute as I continue reading. Alma considers this approach should be adopted for two reasons. First, the states argues that race neutral benchmarks the text of the Voting Rights Act. Section 2 requires political processes be equally open. What that means, the state asserts, is that the state map cannot impose obstacles or burdens that block or seriously hinder voting on account of race. These obstacles do not exist in the state's view, where a map resembles a map that never took race into account. Second, Alabama argues that the relevant framework ends up requiring racial progressive proportionality in districting. According to the state, the relevant framework demands that where another majority black district could have been drawn, it must be drawn. And that's where proportionality, Alabama contends, is inconsistent with compromise that Congress struck. Okay, interesting argument. To apply the race neutral benchmark in practice, Alabama would require the plaintiffs to make at least three showings. First, the illustrated plan the plaintiffs adduce for the first precondition cannot have been based on race. Okay. Second, plaintiffs must show at the totality of the circumstances stage, the state's enacted plan diverges from the average plan that will be drawn without taking race into account. And finally, plaintiffs must ultimately prove that any deviation between the state's plan and a racial neutral plan is explainable only by race, not, for example, geography and demography. Okay. As we explained below, we find Alabama's new approach to Section 2 compelling neither theory nor practice. Okay. All right. Tell me why. It's an interesting argument from Alabama. I'm not sure how I think. Tell me what you think, and I'll let you know how well your argument works. Section 2 prohibits states from imposing any standard practice or procedure in a manner which results in denial or abridgment of the right of any citizen to vote on account of race or color. What that means, Section 2 goes on to explain, is that political processes in the state must be equally open, such that the minority voters do not have less opportunity than other members of the electorate to participate in political process and to elect representatives of their choice. We have understood the language of Section 2 against the background of hard-fought compromises that Congress struck. To that end, we've reiterated that Section 2 turns on the presence of discriminatory effects, not discriminatory intent. Well, the new language does at least partially speak to that. That's fair enough. Okay. All right, fair enough. And we've explained that it's patently clear that Congress has used the words on account of race or color in the act to mean with respect to race or color and not to connotate any required purpose. All right. Individuals thus lack equal opportunity to participate in the political process when a state's electoral structure operates in a manner that minimizes or cancels out their strength. That occurs when an individual is disabled from entering into the political process in a reliable and meaningful manner in light of past and present reality, political and otherwise. A district is not equally open, in other words, when minority voters face, unlike their black peers, block voting along racial lines, arising against the backdrop of substantial racial discrimination within a state that renders a minority vote unequal to non-minority voter. So basically, the Supreme Court is saying in so many words that your feature is actually a bug. The fact that you are not taking race into account is actually partly the problem because the Voting Rights Act says on account of race. That means with respect to race. And we also look to effect. So the fact that it's racially blind is perhaps part of the problem. because Congress has made a different choice. Okay. The state's reading of Section 2, in contrast, runs headlong into a precedent. Alabama asserts that a state's map does not abridge a person's right to vote on account of race if the map resembles a sufficient number of race-neutral alternatives. But our cases have consistently focused on purpose of litigation, on the specific maps that the plaintiff offers as competing maps. Deviation from that map shows it's possible the state map has a disparate effect. The remainder of the test help determine whether the possibility is reality. Okay. So basically, the problem is that Alabama's argument does not satisfy the Supreme Court precedent. We've already set out a standard on this issue, and your alternative is not in compliance with our thing. And the fact that they can show these competing maps then means, well, the fact that the state's maps are kind of irrelevant as to that aspect. So we should just move forward with the test that we have. So your computer generated maps are interesting and all, but not how we do things. Okay. A state's liability under Section 2, moreover, must be determined based on totality of circumstances. Yet Alabama suggests there's only one circumstance that matters: how the state map stacks up against a relative to the benchmark. A single-minded view of Section 2 cannot be squared with the Voter Rights Act demand the courts employ a more refined approach. Okay. And we decline to adopt an interpretation of Section 2 that would revise and formulate our threshold inquiry that's been the baseline of our jurisprudence. Okay, so we're kind of leaning on, so we're basically leaning on a couple things here. We're leaning on we looked at the history, so we so far in this case, we've looked to the history of how the current language of Section 2 came about, right? We had language before. In the language before, we talked to like a but-for causation, right? And that the voters didn't like that and complained to their congressman. And Congress changed the law to have a broader race consideration than the previous version of the law. And we adopted our new case law in compliance with what Congress wanted, because, that's what we do. So your approach of this completely race neutral approach, where you look just basically to intent and not to effects, is kind of exactly counter to what Congress did in this very nuanced view. Congress said that we're supposed to take race into account, essentially, in so many words. And you have failed to do that. And we have been applying this standard since 1982, and we're not going to overturn it now because of the reasons we've been saying. Okay. I think I can see where the dissent is going to go. We may still have to read some of the dissent to see if I find it more persuasive, because I don't know if this is the strongest argument I've ever heard in my life, but I'm also not sure it's wrong. We get to think about it in real time. All right. A state's liability under Section 2, moreover, must be determined based on totality of circumstances. Okay, we read that section. Alabama also argues that race-neutral benchmark is required because our existing jurisprudence inevitably demands racial proportionality in districting, contrary to the last sentence of Section 2. But properly applied, the framework itself imposes meaningful constraints on proportionality, as our decisions have frequently demonstrated. In a prior case, for example, we considered the permissibility of a second majority minority district in North Carolina, which at the time had 12 seats in the U.S. House and 20% Black voting population. The second majority minority district in North Carolina was drawn 160 miles long and for much of its length no wider than an interstate corridor. Yeah, that doesn't sound very compact. The district would wound in snake-like faction through tobacco country, financial centers, and manufacturing areas until it gobbled up enough enclaves of Black neighborhoods. Indeed, the district was drawn so imaginatively that one state legislature remarked, if you drove down the interstate with both car doors open, you'd kill most of the people in the district. Though North Carolina believed the additional district was required, we rejected the conclusion, finding instead those challenging the map stated a claim of impermissible racial gerrymandering. In so hold, we relied on the fact that it was not reasonably compact. Yeah, that's that. Yeah, and is not reasonably compact. That yeah. There's only so bizarre. We're going to let you make your shapes. But North Carolina has concentrated a disparate minority population into a single district by disregarding traditional districting principles, such as compactness, contiguity, and respect for political subdivision, and reapportionment plan that includes in one district individuals who belong to the same race, but otherwise separated by geographic and political boundaries, raise constitutional concerns. Fair. Fair. The same theme emerged in our 1995 decision, Miller versus Johnson, where we upheld a district court's finding that one of Georgia's 10 districts was the product of an impermissibly racial gerrymander. At the time, Georgia's black voting population was 27%, but there was only one majority minority district. To comply with the act, Georgia thought it necessary to create two more majority minority districts, achieving proportionality. But like North Carolina, Georgia could not create the districts without flouting traditional criteria. One district centered around four discrete, widely spaced urban centers that had absolutely nothing to do with each other, and stretched the districts hundreds of miles across rural counties and narrow swamp corridors. Geography, we said of the map, is a monstrosity. That's funny. In Bush versus Vera, plurality of the court again explained how traditional districting criteria limited any tendency of the Voting Right Act to compel proportionality. The case concerned Texas' creation of three additional majority and minority districts. Though the districts brought the state closer to proportional representation, we nevertheless held that they constitute racial gerrymander in violation of the 14th Amendment. That was because the districts had no integrity in terms of traditional neutral districting criteria. One of the majority black districts constituted of narrowly bizarre shape and tentacles. The proposed majority Hispanic district resembled a sacred Mayan bird with spindly legs reaching south and a plumed head rising northward. The point of all this is a simple one. Forcing proportionality representation is unlawful and inconsistent with the court's approach. And the numbers bear out this approach as well. At congressional level, the fraction of districts in which black preferred candidates are likely to win is currently below the black share of eligible voters in every state but three. Only one state in the country, meanwhile, has attained a proportional share of which Hispanic preferred candidates are likely to prevail. That's because as residential segregation decreases, it has sharply done since the 1970s, satisfying traditional criteria, such as compactment requirement, that became more difficult. Indeed, as amici supporting the appellees emphasize, Section 2 litigation in recent years has rarely been successful for just that reason. Since 2010, plaintiffs nationwide have apparently succeeded in fewer than 10 lawsuits, and the only state legislative or congressional districts that were redrawn because of successful Section 2 challenges were a handful of state House districts near Milwaukee and Houston. By contrast, numerous lower courts have upheld districting maps where, due to minority populations, geographic diffusion, plaintiffs could not design additional minority districts or satisfy compactness. So, as black people became less um, geographically concentrated, it became harder and harder to draw those districts in a way that satisfied traditional criteria. And so a lot of people sued, but the alternative maps looked like nightmare fuel. So we're not going to let you have the nightmare fuel. That makes sense. I buy that. Okay, fine. The same has been true of recent litigation in this court that found a Texas district did not violate the law because the geographic and demographics of South and West Texas do not permit the creation of any more than 7 Latina districts that exist under the current plan. Okay. Reapportionment, we've observed, is primarily the duty of the states, not the federal courts. Properly applied, the factors help them ensure this remains the case. In response to this themselves emphasize, Section 2 never requires adoptions of districts that violate traditional redistricting principles. Its exacting requirements instead limit judicial intervention to those instances of intensive racial politics where excessive role of race in the electoral process denies voters equal opportunity to participate. Hold on one second. Excuse me. Thank you. Although we're content to reject Alabama's invitation to change the law on the ground the state misunderstood Section 2 and our decisions implementing it, we also address how race neutral benchmarks would operate in practice. Alabama's approach fares poorly on that score, which further counsels against our adopting it. The first challenge to existing law that Alabama would require is prohibiting the illustrative map that plaintiffs satisfy from being based on race. Although Alabama is not entirely clear whether, under its view, plaintiffs' illustrative plans must not take race into account at all, or whether they just might not prioritize race, we see no reason to impose the rule. When it comes to considering race in the context of districting, we made clear there's a difference between being aware of racial considerations and being motivated by them. That's pretty thin, slice, but that's what we're doing. The former is permissible, the latter is not. That's because racial redistricting legislatures will almost always be aware of demographics, but race consciousness does not lead inevitably to impersonal race discrimination. The question of whether additional majority minority districts can be drawn involves quintessentially race conscious calculus. At the same time, however, race must not be the predominant factor in drawing district lines unless there's a compelling reason. Race predominates in the drawing of district lines, or case explains, when race neutral considerations come into play only after the race based decision has been made. That may occur where race for its own sake is the overriding reason for choosing one map over others. While the line between racial predominance and racial consciousness can be hard to discern, yeah, I would think so, it was not breached here. The plaintiffs relied on illustrated maps produced by an expert. The expert testified that while it was necessary for him to consider race, he also took several other factors into account, such as compactness, contiguity, and population quality. He testified he gave all those factors equal weighting. When asked whether race predominated in his development, he responded no. It wasn't consideration. This is a Section 2 lawsuit after all, but it did not predominate or dominate. Okay. This may or may not be voting affirmative action porcelain, but if it is, it's a law that Congress passed. So that's what we're doing. Congress gets to make choices. Talk to your legislator about it. It's not for the courts to fix. The district court agreed. It found that Cooper's testimony highly credible. It commended Cooper for working hard to give equal weight of all traditional redistricting criteria. The court also explained that Alabama's evidence of racial prominence in the maps was exceedingly thin. Alabama's expert testified that he never reviewed exhibits to the report. Choices? What do you mean? Yeah, Congress made a choice. Congress wrote a law. Congress made a choice. Yeah. They could have done something different. They passed this law. Ryan further testified they could offer no conclusions or opinions as to the apparent basis of any individual line drawing decisions. By his own admission, the analysis of any race predominant in the map was pretty light. The district court did not err in finding the race did not predominate in Cooper's map in light of the evidence before it. The dissent contends that race nevertheless predominated in both Cooper's and Dushin's map because they were designed to hit express racial targets, namely to 50% plus majority minority districts. This argument fails in multiple ways. First, the dissent's reliance on a different case is mistaken. In this case, the court was unwilling to conclude the state maps were produced in a racially predominant manner. Instead, we remand for the lower court to conduct the predominance analysis itself, explain that the use of express racial target was just one factor among others the court would have considered as part of a holistic analysis. Justice Thomas dissented in the relevant part, contending that because the legislature sought to achieve a black voting age population of at least 55%, race necessarily predominated in decision making. But the court does not join in that view, and Justice Thomas again dissents along those same lines. The second flaw in the dissent's proposed approach is the inescapable consequence. The prior case must be overruled. According to the dissent, racially predominance plagues every single illustrative map ever offered by plaintiffs at the first step of the analysis. For all those maps were created with express targets in mind, they're created to show, as our case is required, that additional majority minority districts could be drawn. That's the whole point of the enterprise. The upshot of the approach the dissent urges is not to change how the law is applied, but to reject its framework outright. The contention that map makers must be entirely blind to race has no footing in our law. The line we have long drawn is between consciousness and predomination. Plaintiffs adduced at least one illustrative map that comports with precedent. That they're required to do satisfies no more than the step of Gingles. Okay, I mean, this makes sense. It relies a little bit on precedent value. So if you were doing this for the first time ever, I'm not sure that you'd come out this way, but the precedent does exist, and the Supreme Court is supposed to be reluctant to overturn precedent to varying degrees of reluctance. And, it is the precedent. So Chief Justice Roberts, though, is doing something Chief Justice Roberts does like to do. He does like to lean on precedent when he can use it to justify his decision making. So that is a characteristic of Chief Justice Roberts in several of his decisions. Is like where he can lean on precedent to justify his decision, he really likes doing it. So, just saying. The next condition Alabama would graft onto Section 2 of the Voting Rights Act is requirement that the plaintiff demonstrate at the totality of the circumstances stage the state enacted the plan contains fewer minority-majority districts than race-neutral maps. If it does not, then Section 2 should drop out of the picture. Alabama argues that is what should have happened here. It notes that one of the plaintiff experts used an algorithm to create 2 million plans for Alabama without taking race into account in any way in the generation. Of those 2 million race-blind plans, none contained 2 majority districts, when many plans did not contain any. Okay. Alabama also points to a race. Really? None of them? Okay. Alabama also points to a race-neutral computer simulation conducted by another expert, which produced 30,000 maps. As with his maps, none of the maps that guy created contain 2 majority black districts. Alabama thus contends that because the law sufficiently resembles race-neutral maps created by those experts, all the maps lacking 2 majority black districts, the law does not violate the relevant section. Alabama's reliance on the maps created by the experts is misplaced. For one, neither the experts' map accurately represent the districting process in Alabama. The first experts' maps were based on old census data from 2010 instead of 2020, and ignored certain traditional districting criteria, such as keeping together communities of interest, political subdivisions, or municipalities. And the other experts' maps failed to incorporate Alabama's own districting guidelines, including keeping together communities of interest and preserving municipal boundaries. Hmm. Okay. But even the maps created by the experts were adequate comparators, we could not adopt the map comparison test that Alabama proposes. The test is flawed in the fundamentals. Districting involves myriad considerations: compactness, contiguity, political subdivisions, national geographic boundaries, county lines, pairing of incumbents, communities of interest, and population equality. Yet quantifying, measuring, prioritizing, and reconciling these criteria requires map drawers to make difficult, contestable choices. And it's easy to imagine how different criteria can move the median map toward different distributions, meaning the same map could be lawful or not, depending solely on what the map maker set out to do. For example, the scientific literature contains dozens of competing metrics on issues of compactness. Which one of those metrics should be used? Well, I want to compare perimeter to area personally and look for the best ratio, but that's me. What happens when the maps they produce yield different benchmark results? How are the court to decide? Alabama does not say. It offers no rule or standard for determining which of these choices are better than others. Nothing in the relevant law provides an answer for either. In 1982, the computer map-making software that Alabama contends plaintiffs must use to demonstrate the level of deviation did not even exist. And neither Section 2 of the relevant law nor the fraught debate that produced it suggests equal access to fundamental rights of voting turns on computer simulations that are technologically complicated, expensive to produce, and available only to a small cadre of university researchers that have resources and expertise to run them. Ouch. One final point bears mentioning. Throughout these cases, Alabama has been repeatedly emphasizing that the law cannot violate Section 2 because none of the plan's 2 million odd maps contain more than one minority-majority district. The point is 2 million is a very big number and the sheer volume most matters. But as elsewhere, Alabama misconceives the math project it expects the courts to oversee. A brief submitted by 3 computational redistricting experts explains the number of possible redistricting maps is at least in the trillions of trillions. Another map reports that the number of potential maps may be orders of magnitude higher. The universe of all possible connected population balancing district maps that satisfy the state requirements is likely in the range of Google's. 2 million maps, in other words, is not many maps at all. And Alabama's insistent reliance on that number, however powerful it may sound in the abstract, is close to irrelevant in practice. What would the next million map show? The next billion? The first trillion of trillions of trillions? Answerless questions all. Is computationally intractable and thus effectively impossible to generate a complete enumeration of all possible districting plans. Even algorithms that attempt to create manageable sample of astronomically large universe do not constantly identify an average or median. So all your computer simulations are worthless. Okay, well, that's one way to go. Computers suck. Maybe when you get quantum computing, give us another call. Section 2 cannot require the courts to judge a contest of computers when there's no reliable way to determine who wins or even what the finish line is. Oof. Alabama's final contention with respect to race-neutral benchmark is it requires plans to demonstrate any deviations between the states, enacted plan, and race-neutral alternatives can be explained only by racial discrimination. We again find little merit in the proposal. As we've already explained, our precedent and the legislative compromise struck in 1982 clearly rejected treating discriminatory intent as a requirement for liability. Yet Alabama's proposal is even more demanding than the intent test Congress jettisoned. So yeah, basically you want us to basically go backwards of what Congress did. Demonstrating discriminatory intent we've long held does not require plaintiff to prove the challenge acts relied solely on discriminatory purpose. Alabama's proposed approach stands in sharp contrast to all this, injecting into the effects test of Section 2 an evidentiary standard that even our previous purposeful discrimination cases eschew. Nice. Alabama finally asserts that the court should outright stop applying Section 2 in cases like this because the text of Section 2 does not apply to single member redistricting and because Section 2 is unconstitutional. What? We disagree. Alabama first argued Section 2 does not apply to single member redistricting. Echoing Justice Thomas's concurrence in Holder, Alabama reads Section 2's reference to standard, practice, or procedure to mean only methods for conducting a part of the voting process that might be used to interfere with the citizen's ability to cast the vote. Examples of covered activity will include registration requirements, the locations of polling places, the time the polls are open, the use of paper ballots as opposed to voting machines, and similar aspects, but not a single member districting system or selection of one line over another. Okay, this understanding of Section 2 cannot be reconciled with our precedent. As recounted above, we've applied Section 2's state districting maps in an unbroken line of decisions that stretch 4 decades. The majority's dismissal of the 2 million figure is equivalent to saying the 22 flips of a coin that all lands heads tells us nothing about the fairness of a coin. I'm not sure about that example or not. I mean, the probability of it coming up heads each time is 1/2, right? So if it comes up heads 22 times in a row, is it a fair coin? I'm not sure the example works, but it's an interesting idea. Even though we've invalidated portions of the single district map, Alabama's approach would require abrogating the precedent. Although, to be fair, if the court's numbers are correct, then it's more like flipping a coin once in determining whether it's fair because of the proportion. If we're really talking about trillions of possible maps, and we're talking about like 2 million, then 2 million in the context of trillions and trillions, I'm not even sure we flipped the coin once by the analogy, but okay. We just declined to take that step. Congress is undoubtedly aware of construing Section 2 to apply to districting challenges. It can change that if it likes, but unless and until it does so, statutory stare decisis councils are staying the course. The statutory text in any event supports the conclusion that Section 2 applies to single member districts. Alabama's own definition of procedure in the manner or method of proceeding in a course of action. But the manner of proceeding in the act of voting entails discrimination, determining in which districts will vote. The fact that the term procedure is preceded by the phrase qualification or prerequisite to voting does not change its meaning. It's hard to imagine many more fundamental prerequisites to voting than determining where you cast your ballot or even who you're eligible to vote for. Perhaps for that reason, even if Alabama does not bear the courage of conviction on this point, it refuses to argue that Section 2 is inapplicable to multi-membering districts, though textual arguments apply with equal force in that context. Yeah. Maybe Trenton, maybe you're right. I think this leans pretty heavily on precedent. I think this is really, I think this is just leaning really heavily on precedent, which isn't necessarily invalid. I'm not sure that if you were deciding this for the first way time now, you'd come out the same way, to be honest. You might be right, Trenton. I think, in fact, I think you probably are more right than not. I think that all this is not. I think that this decision is leaning very heavily on precedent, and everything else is kind of a little fluffy. So your criticisms are well noted, and to some degree at least valid. The Senate also contends that applying Section 2 to districting system, the ballot focuses on 1960s rights. But history didn't stop in 1960. As we've explained, Congress adopted the amended Section 2 in response to the 1980 decision, a case about districting. And as the Senate itself acknowledges, Congress drew the current operative language from a 1973 decision, a case that was also about districting. That was not lost on anyone when Section 2 was amended. Indeed, it was the precise reason the contentious debates over proportionality raged, debates that would have made little sense if Section 2 only covered poll taxes and the like, as the dissent contends. I just want to go for maximal compactness, by the way. If I had a vote on such things, I just want to go for maximal compactness, and I want to determine compactness by by length of border compared to area of district, and look for the best ratio. That's what I want to do. And then there's basically only one way to draw that map. And Google's actually done it. I could actually pull it up. I can show you what that would look like. Uh, Hold on. Or someone did it. Um, let's see. Or at least it'll give you a pretty good idea of what it would look like. It won't be perfect, but you know. Let's see. There's a map somewhere. Maybe it was the New York Times that did it. Uh, let's see if I can find this real fast. Lord. I hate when I try to find something on the fly and then you just can't find it right away. And it's like, okay, everyone wait while we, talk amongst ourselves. Oh, if it was 538 that did it. Aha. Okay, great. I found what I was looking for. Yay. All right. So this is all right. This is 2018. So this is last census's map. So this is not current as of now. This would be based on 2010 census. But I'll give you the idea of what we're talking about. All right. So let's see. All right. So I'll make this a little bit bigger. No, it's too big. All right. So this was the map that existed in 2010. This is the map that existed in 2010. And um and if you so you can see in these maps how you got lots of weird shapes like Ohio. Ohio is pretty good here. You can see like how you got some weird edges and things are like a little bit ungangly and stuff like that, and sort of how the edges are constructed and things like that. Little little untidy. And you can see something like, Texas maybe, same kind of problem, you know, kind of weird looking district somewhere. So this is the districts that actually existed. If you did maximally compact districts and also tried to respect county borders, the map would look more like this. And now you got the edges are a lot nicer because each district is as compact as possible. If you go compact as possible without uh, county lines, you do this map. So if you don't respect county boundaries and you just go maximally compact, you wind up with this map. If you respect county boundaries, you wind up with this map. Either one would be fine by me. In terms of what that would do in terms of the reality on the ground, um, in 2010, there were 168 usually Democratic districts, 72 competitive districts, and 195 Republican districts. So if you go maximum compactness all the way, it would make the Republicans a little bit more popular. So instead of 168, it would be 151 Democrats. And if you respected boundaries, it'd be 155. But it's mathematically precise, and I like the mathematical precision of it all. Because there's basically only one way to draw this map. Because it's maximally compact. So there's only one way to draw this map. And there's more than one way to draw this map, because what does it mean to respect county lines? So there's more than one way to draw this map. But personally, if I had my choice, I'd just go with this. Screw the county lines, whatever. Screw the county lines. I like this because it's mathematically precise. That's my dream. But pressing on. I'll take either one. Either one's fine. Um, and because they're maximally compact, it should make it very easy for you to go find a polling location. Because kind of, they're maximally compact. So by definition, you don't have to travel as far. So that's nice. So that's plus. So, anyways, I wrote my my undergrad political science thesis, and I use the words very loosely because it wasn't that rigorous. But I wrote it on voting methodology, so I have some familiarity with this, although that was a long time ago. I was getting a BS in political science, incidentally, uh, instead of a BA in political science, and so it involved math, and so I did mine on political methodology using mathematics and sort of how the different voting methodologies work mathematically. So it wasn't new research, obviously. It's an undergrad paper. So it was summation of previously existing research. So it wasn't anything new or novel, but it was, a culmination of existing research. So, anyways, pressing on. We also rejected Alabama's argument that Section 2 redistricting is unconstitutional under the 15th Amendment. According to Alabama, the amendments permits Congress to legislate against only purposeful discrimination. But we held over 40 years ago that even if Section 1 of the 15th Amendment prohibits only purposeful discrimination, the prior decisions of this court foreclose any argument that Congress may not pursue Section 2 of the 15th Amendment, outlaw voting practices that are discriminatory in effect. The Voting Rights Act bans electoral changes that are discriminatory in effect is an appropriate method of promoting the purposes of the 15th Amendment. As our law has recognized, we reached the very same conclusion in South Carolina versus Katzabon, a decision voted right after the VRA was first elected. Yeah. So make me king, and I will create maximally compact districts, and I'll also change our voting method to literally anything other than first past the post. I whatever. We'll just do single transferable vote and call it a day. It's fine. So make me king, and I'll put that in the Constitution. That'll be good. Alabama further argues that even if 15th Amendment authorizes effective Section 2, the amendment does not authorize race-based discrimination as a remedy. But for the last 4 decades, this court and other federal courts have repeatedly applied the effects of Section 2 as interpreted in the case law and under certain circumstances have authorized race-based redistricting as a remedy for state districting maps that violate Section 2. In light of the precedent, including prior law, we're not persuaded that Alabama's arguments that Section 2 interpreted in the law exceeds remedial authority of Congress. The concern that Section 2 may impermissibly elevate race and allocation of political power within the state is, of course, not new. Our opinion today does not diminish or disregard that concern. It simply holds that faithfully applying the precedent does not bear them out. Okay, that kind of makes sense. And let's speed read. Let's speed read some of the dissent and see if it has anything to offer us. So you think it's unconstitutional? And you also don't think that this is a voting prerequisite or challenge. So you just disagree with the precedent. Justice Gorsuch in the dissent? Yep. Okay. Stare decisis should be no barrier. Was based on flawed method. It's proved incapable of principal application. They just think the precedent is wrong. They think it's unconstitutional. Oof, hardcore. What does the 15th Amendment actually say about this issue? Hold on. I need a copy of the 15th Amendment so I can decide if it's unconstitutional or not. The rights of the citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. The Congress shall have the power to enforce this article by appropriate legislation. I don't know, man. That's a tough call. Thank you, Sandra, for the gift memberships as always. I appreciate it. That's awesome. Yeah. Okay. So they disagree with the precedent. They read the Constitution in a different way. Pretty sharp disagreement. And Chief Justice Roberts leans heavily on precedent. Mm, I don't know. I don't know. I haven't been thinking about this long enough to have a strong opinion on this, to be honest. Um, I don't know. I haven't been thinking about this long enough. The 15th Amendment is not one of my areas of greater expertise. I admit to that. I admit to my weaknesses. I'm not super strong in 15th Amendment jurisprudence. There's a lot of law out there. It's hard to be expert on all of it. Okay. I don't know. All right. Well, I guess that will end this for a deep dive for the moment. Maybe when I have some more time or something, I'll spend some more time with the dissent, and maybe I'll produce another video about it, thinking about it and going over it in more detail. But the majority's okay. Well, if you go with stare decisis, then the majority's opinion certainly works, and you can call it a day. The dissent rejects all that and thinks it's unconstitutional in the first place. Which, oh my god, okay. Um, all right. Unboxing tomorrow with the oven. Well, I'm having a bit of an existential crisis on the oven. I'm not sure which oven I should pick. So, I already ordered one oven, but I was looking at a different oven. Um, so I'm not sure which oven is best oven. Um, Let me see if I can pull it up and we can discuss oven choices for a minute. Yeah. All right, hold on. All right. So, am I still signed in over here? No, of course not, because that'd be way too convenient. Um, God damn it. Trying to figure out my own account here. Hold on. I have to do two-step verification. Just what the damn model number. Um, Damn it. I have to relog into my account just to figure out what thing I ordered. Hold on. Two-factor authentication. All right, this Cuisinart one. All right. So you guys can help me pick between these two and let me know what you guys think. All right, share. Screen, share, window, share. All right. All right. So this is the one I ordered. This is the one I ordered. This Cuisinart convection toaster, stainless steel. 217 was the best price for like the last year on it, by the way. It was nice. And that's coming in the mail tomorrow. 15 functions, including dual cook and speed convection. It comes also with a ceramic pizza stone, which is kind of cool, I guess. It can apparently fit a 9 by 13-inch baking pan in there. That's pretty cool. So that's one. And then the other one I was looking at was this wall air fryer, 12-in-1 air frying convection oven, rotisserie, roast, bake, dehydrate, 12 cooks, presets. It's got presets, man. It's got presets for French fries, drumsticks, steak, sandwich, fish, chicken, shrimp, fruit dry, pizza, reheat, preheat, and unfreeze. Like, oh, that's pretty cool. It's got all those wonderful preheat things. That sounds pretty good. 12 quart. You have this. You have this air fryer, Sandra. You have this wall one. So yeah, this has 22. This has 2,800 ratings, 4.4. This is 4.5 with 3,800 ratings. So it's pretty close in it. 1,700 watt. What do we think? And it's on sale. Yeah, what do we think? Is the capacity similar? I'm not sure. This is 12 quart. I guess it gives us the dimensions. So it's 10, 10 inches by 10 inches by 7.5 inches. And the other one is, well, a little bit bigger, it looks like. Looks like it's a lot wider, 20 inches wide. So it looks like the other one is a lot wider. An entire chicken in there. This one will do an entire chicken. Go down the bottom, it'll have more specs. See, it will fairly fit a 13-inch pizza. That's nice. You see the wall? You think the wall's the good one? This one doesn't quite specify, like, I mean, it has a pizza setting, but it doesn't say what size pizzas it keeps in there, right? Old chicken, someone did in their thing. Well, Jules Buddha, yeah. Other than narrow, it doesn't seem bad. Yeah, not even like an 8x8 band. It's too narrow. You think? Yeah, it might be too narrow. If it is, if it is 10 by 10 inch, not going to fit a. It's not going to fit a 9x13 baking pan in there now, is it? So yeah, it's the other one's going to be wider. This one is 10 inch by 10 inch. So, well, if it's 10 inches by 10 inches, it can't fit a 12-inch pizza, can it? I mean, logically, right? If it's 10 inches by 10 inches, it can't fit a 12-inch pizza because it's not big enough. This one can fit a 13-inch pizza. I think I'm going to stick with the one I bought. I think I'm going to stick with the Cuisinart one. Yeah. I think I'm going to stick with the Cuisinart one. Yeah, I think I'll stick with the Cuisinart one. Stick with the bigger one. All right. That's coming tomorrow. Wait, more pizza or whole chicken? Well, yes. I don't eat a lot of pizza, but I suspect that's going to change in the near future. So we'll go with the Cuisinart one. And I'll figure out how to, I'll figure out the settings for like defrosting and stuff on there. I'm looking forward to making steak with it. We're going to do the same steak we did before, but we'll finish it off in the toaster oven. That'll be badass. Yeah. All right. Well, thank you for helping me with my Amazon selections. Will it fit in the cupboards? I don't know. Probably not. That's all right. I wasn't planning on keeping it in the cupboards. It'll sit on the countertops. That's what I normally do. Yeah. All right. So that'll do the rest for this. I hope you've enjoyed this deep dive Supreme Court stream and also toaster oven selection stream. I've been on civil law. Until later, my friends, I hope all is well. Cheers, my friends, and goodbye.